Thank you guys for joining in today for another video from Firearms Legal Protection. Today I am joined by two experienced attorneys, Bill Grammer and Terry Johnson, and we are going to talk about a topic that I've seen some of my friends and family talking about. We've got some questions here at FLP about, and that is the controversy or confusion related to Remington Firearms, one of the oldest gun companies in America that has had some legal trouble. So, Bill, Terry, you want to kind of, I guess,
Sure.
How do we start this? How do we kick this off?
Well, but before we do, I think most people know me. I'm the Executive Vice President of Firearms Legal Protection, but let's take a moment and introduce Bill. Bill is our Regional Director. Bill is a very experienced attorney. Bill, can you just take a moment or two and tell us about you and some of your great accomplishments, including the fact that you may not know this, but Bill is also a pilot. Bill was a former police officer in addition to being an attorney. I know he's got two fabulous kids. You can probably see them behind him. And we're very happy to have Bill Grammer on our legal team at Firearms Legal Protection. But Bill, why don't you say hello for a few moments?
Well, thank you very much. And I'm very glad to be part of the team. My background as a cop has certainly helped. 23 years practicing criminal defense, lots of cases that involve force. So I feel like I'm in the right place with the right people, with a great product that the people, if they understood, everyone would have it. So I'm happy to be part of the team that helps people understand what we really do and why they need it. My police experience certainly brings a lot to this type of conversation in that I've been in 2 shootings. I've been on a tactical team. I build my own rifles. I hand load ammunition. Guns have always been a part of my culture since I was very young. And so now being in the industry, so to speak, is quite the blessing.
Well, Bill, we are very, very happy to have you aboard. You've made some great contributions thus far, and we are looking forward to many, many more. So thank you. With that in mind, let's talk about this Remington case. I mean, wow, $73 million. That's a lot of. I mean, that's almost as much money as Plenty makes in a year. So, right. we gotta kind of unwrap this. So, what does this mean, Bill? $73 million. What does this mean?
Well, it was a settlement and not a verdict. It's probably the first thing that should be noted, which means the insurance companies. The insurance companies made the decision. Remington was done. There was no Remington at the time of this decision. So it was 4 insurance companies, if my memory serves me right, that got together and decided we're gonna pay out everything that the policy will allow us to pay. So they got full limits. There is no more to get. So that's the reason that it was able to be settled like that.
So you said, a settlement versus, let's say, a verdict. So basically, so everyone's clear, this did not go to trial. In other words, like you would see on TV where there's evidence presented and there's a jury and a judge, and this is just basically they negotiated this. Is that correct?
Right. And we don't know all the factors that they use to come to their decisions. We can only speculate. But as you well know, the bean counters in insurance companies look at things much different than the people that are actually involved in the suit. The victim, the defendant, they don't have the same interests. So it was all just a money decision, presumably on the insurance company's part. And of course, the attorneys are going to get a large amount of that money, probably a third. That's how that normally works.
Well, and let's think about that for a moment. This case has been going on for about 9 years.
Right.
And, if you take the difference between a plaintiff's attorney, which again, the family of the alleged victims, I'll say, they brought the suit. So a plaintiff's attorney, the way he or she generally works, they will charge by the hour. They'll take the case on and they'll do it like you kind of said, Bill. If we win, I'll get a third of this. So a lot of places, there's no money up front. However, when you look at Remington, they have to pay for their attorneys, win or lose.
Right, and that's the hourly rate, not the plaintiffs. The plaintiffs is, we don't get paid unless you get paid. You've all heard the ads, but the insurance companies are paying their attorneys hourly, and God only knows what their rate is.
Yeah, and think about an hourly rate for 9 years. I mean, wow,
multiple attorneys, multiple staff, investigators, depositions, transcripts. The money just goes through the roof in a case like this.
And going back to what you said, it gets to a point where even if you went down the road and you realize maybe I can win this, you just may want to stop the bleeding at some point.
Right. And again, the decisions are being made by people who don't have a dog in the fight, so to speak. They're not emotionally attached to the case. It's all statistics for them. Where if it's, Remington themselves, they may have said, no, we're not going to settle. We want to prove that we didn't do anything wrong. And they never got that opportunity.
And Bill, you brought up earlier that that the company was long gone before this settlement happened, that Remington Arms had gone through bankruptcy and disbanded and reformed multiple times. And so if anybody's looking at this and they're looking at the current holder of Remington Arms and begrudgingly, or they're looking at the current holder of Remington Ammunition, no, they weren't involved in this. So
totally different.
Don't boycott them or get angry at those companies for what the insurer of the previous entity has done.
And one thing to keep in mind with that. Oh, I'm sorry. Go ahead, Bill.
Well, I was just going to mention that the case isn't actually over because the bankruptcy court has not approved it yet. But it's going to be a rubber stamp. It just hasn't happened yet.
Yeah. Yeah, I was just going to say one thing to keep in mind with these insurance companies. If you have a carrier that's going to back you and you say, hey, nope, Remington will say, I don't want to move forward with this. I want to fight it out. The problem is the insurance companies stop paying at that point. And if there is a verdict against you, you're on your own.
That's right.
So that power that the insurance company has is just monumental.
Wow.
Right. And I mean, they're the one writing the check, so they should have the power to make some certain decisions. And this is just the way this is set up in our society, that they really do pull the strings.
So this is not an issue of guilt at this point, right? This is just, we've just said we're going to just wash our hands of this at this point, and we're going to move on, and it's just going to cost us $73 million to wash our hands of this.
Wow.
And one of the things to note is I'm sure that there's some sort of non-disclosure involved. So we may never know exactly why or what criteria they use to come to this decision. I've not seen anything that indicates fault on anyone's part or admitting anyone did anything wrong, obviously other than the shooter, but Remington did anything wrong. So it's an interesting precedent because it's very, very unique in its facts. So people that think now all gun manufacturers are going to get sued anytime anything happens is simply not true. This was a very narrow exception to the laws that protect those gun companies and their manufacturing, just like the automobile industry, from someone that takes their product and uses it illegally.
Well, you mentioned that, and that's kind of interesting because there is a statute on the books. And I just want to make sure I read this right. It's the Protection of Law, strike that, it's the Protection of Lawful Commerce and Arms Act, PLCAA, P-L-C-A-A. And it for the first time in 2005, and I want you to think about this, prior to 2005, gun manufacturers were being sued all over the place. People were bringing frivolous lawsuits and other things along those lines. But since PLCAA came into place, it basically put the gun industry in line with like automobile companies, right? So, I mean, think of it this way. If you're driving down the road and you're in a Ford, a GM, or whatever kind of car you're in, and, someone steals that car, you're driving, you stop, you get gas, someone steals the car, drives away with it and runs over 5 or 6 people, you can't go back after that auto manufacturer. Prior to 2005, people were coming after the gun manufacturers for those things. But 2005 changed that with PLCAA, P-L-C-A-A. Bill, tell us a little bit more about that.
Well, the thing to note is the cost of those frivolous lawsuits is enormous. And that's what they wanted. They wanted to try and put these gun manufacturers out of business just with lawsuit after lawsuit after lawsuit, even though they would lose. And the perfect example was what you gave, Terry, about taking a car and running people over with it. That's not GM's fault. And nor is it someone take some other object and use it against what it was designed to do illegally. And that's been in American jurisprudence for forever. It's only the fault of the actor, not any other, collateral people that had no intent to harm. And of course that's the argument here.
Yeah, and I think that's really interesting to compare to something with even the same company. Remington Arms had one of the biggest lawsuits in the firearm industry for the faulty Remington 700 trigger that was deemed to not be safe. And so, it's just like an automobile recall. It is their burden to make that safe, to make that right. And so they handled hundreds of thousands probably of recalls of that trigger. And so this is a totally different situation where they are theoretically protected from having to deal with this kind of stuff.
Right.
Well, they're just like everybody else now, which is great. And again, prior to 2005, it wasn't like this. And, gun manufacturers can be sued, but kind of like you said, Plenty, if there's a defect in the product, and there's a couple of other things that go along with that. If there's a defective product that you put in the stream of commerce, if it malfunctions or something with your warranty, yes, you can be under those. But under PLACA, the interesting thing is this Remington case actually took a turn under one of the exceptions. And, Plenty, you're a marketing guy, you're a marketing director. Tell me what you saw with this, how this, maybe you and Bill can kind of bring our audience up to speed on how the third exception in PLACA actually helped this case move forward.
I'll let Bill to refer to the third exception a little bit more, but what's interesting is because they knew that there was a pretty hard boundary on the user, how it was used, they went more after the intent, the language, the feelings, what they were trying to convey. And Remington is the holder of Bushmaster arms, and I believe it was the Bushmaster XM15. I believe that's the name of their AR-15 style model. And a lot of their advertising was targeted towards people in kind of a 20s, 30s demographic that are frequent buyers of AR-15s, but it's this very like pro-masculine, just be cool. And I think they had some advertisements that were, here's your man card, some things like that. And none of that is strictly illegal in any way at all. But I think they tried to use that language and the placement in video games, violent video games,
right,
to try to say, hey, this weapon is intended to be aggressive. It's intended to be extremely masculine, intended to be violent. Whereas, something that's molded polymer, steel, aluminum, it is not, it doesn't lean one way or another. It just is, right? It's just an item. But the second they put it in the video game, they say, look how you're showing this being used. That's my understanding as a marketer of kind of the language and strategies that they targeted.
But there's a difference between state and federal law, Bill. Why don't you talk about that as it relates to that exception?
Well, what the plaintiffs did was they said that the Connecticut law on deceptive trade practices applied because, well, I don't even know why, but they're saying that it applied because of that advertising, even though the advertising really wasn't deceptive, but it was enough for them to bring it into and get it in front of a court. And the fact that all those advertising gimmicks, if you want to call them that, taken together was just enough to get it in front of the court. And even one of the justices said to bring this lawsuit and to try and convince people that it violates the law is a Herculean task, but it never got that far because they decided to settle. So even a judge in the Connecticut Supreme Court agreed that this would probably fail. I mean, it could pass, but it would be a Herculean task.
Well, but let me ask you this, Bill. How does this, we talk about the interplay between state law and federal law, but if federal law says, hey, under PLACA, you can't do this, how does state law then, for example, Connecticut, we know, Connecticut is not the most friendliest gun community in the country. Right. Is this something we've got to look out for in other, I'll just call them blue states across the country?
Well, the short answer is yes, but again, it was a very narrow holding because of that exception in PLACA. So the attorneys formed their argument based on the exception. A court found that it's okay, probably enough to be heard by a court. We don't know if you're going to win or not, and that's how it moved forward. So it was the federal law with the exception applying the state law deceptive trade practices that allowed this to move forward.
Interesting.
Got it.
And with this, so obviously it's not a criminal proceeding where it would establish case law, but with finding this exception and pulling $73 million out of this exception, do you think that's going to embolden others to target firearms manufacturers, or is this just such a rare, weird one-off sort of thing?
Well, let me just correct one thing there. You know, case law is not just determining criminal; it's determining civil as well.
Right,
So,
meaning not a settlement. I misspoke.
Right, but the mere fact that this was settled has no judicial value whatsoever. I mean, Bill, do you agree with that?
Yeah, there's no court that's going to refer to this as a precedent.
Right.
But of course, people, especially that want to cause harm to the industry or are greedy and want to just go after it for money, they'll use this as a way to try and advance their cause, their perception of their cause. But whether it will proceed, whether it will go forward or not is a whole nother matter.
Interesting.
Well, and again, $73 million, even if you divide that by, let's just say 10 years, that's about $7.3 million a year. And again, I just keep going back to that number. Imagine what Remington had to pay in attorney's fees, investigators, depositions. And if this would have gone on another 3 years, how much would they be out of, a year just in legal expenses? But again, Bill, I don't know about you, but I don't know any attorneys that work for minimum wage. Maybe you do. I don't.
No, thank God I don't. I'd hate to go into law school for that. But still, the bottom line is it's a lot of work. I mean, the amount of hours that must have gone into this case are just monumental. And again, the company is making a financial decision, not an ethical decision. It's a financial decision. And nothing can bring back the lives of those lost. Nothing can fix the hole in the hearts of these parents. So you've got to question some motives of certain companies to go after a number like this. Clearly, it's meant to hamstring or disable a certain part of commerce.
Yeah. Well, do you believe, again, I think we said this earlier, that this was 9 families or 9 people that were killed in this incident out of, what was it, 26? 20? Okay. Does this mean that the others can now come back and ride the coattails of this decision and try and get more money from Remington?
Unlikely. I don't know what the statute of limitations is there, and I don't know what the settlement verbiage was that may or may not, just slam that door, but very unlikely. And those families made a conscious decision to not be involved in this. They could have been. They could have all.
Yeah. Well, that's interesting to note too. That it's not everybody involved. It was a few specific individuals. Yeah.
And I believe 4 of those are adults. The adults who lost their lives, their families participated in this.
Understand. Well, look, Plenty. Let me just ask this again. Our marketing director. Does this give you any kind of pause? Had you heard of anything like this prior to the Remington settlement? And notice I'm using the word settlement, not decision.
Yeah.
Prior to the Remington settlement, do you think about this when you start marketing materials out? Does this give marketers and advertisers, an opportunity to sit back and say, I really need to be careful of what I put out?
A little bit. I would say it's not in the forefront of the minds of all or most advertisers. I think a lot of it depends on kind of your audience, the type of product you produce. In my kind of previous employer, I worked with a lot of lights, lasers, night sights, that sort of equipment. And there was always a conscious effort to avoid people reaching the conclusion of, oh, so this lets me shoot people in the dark. We didn't want to ever write any language that made it look like that. And again, that we were a little bit fearful of a false interpretation But I think the truth in all advertising is just, why is your product valuable? Let's speak to that. And as long as you do that, it's not really an issue. But the second you start exaggerating claims or open yourself up to it could be perceived in some other way, it's probably not naturally going to be a problem. But if somebody really picks you out to be a target, you've left some stuff on the board that they probably could go after.
Yeah, I agree.
So the bigger question as we kind of start to wrap this up is, where do we go from here? I mean, based upon this $73 million settlement, where do we go from here? What's next? What are we likely to see in the marketplace?
Yeah, it's interesting. I think people are going to be a little bit conservative just because they're fearful. Whether it's legitimate or not, you're going to see ads that are just bullet points of stats and facts just for a little while. That's my guess.
Well, the industry is strong. Gun sales are very vibrant. I don't think that it's going to harm the industry, if that was part of your question. I think that the marketers are going to be very careful to be very accurate and, again, conservative, agreeing with plenty. But I don't believe it'll hurt the market. What's helping the market, I would say, more than anything, is the political climate. People are concerned, and those people are out buying items to protect themselves and their family.
You know, the interesting thing is, you know, as we look at this, you know, and plenty, you mentioned this earlier, don't get mad at Remington. You know, don't get mad at any business, firearms business, that has to make a conscious decision to settle. And again, I'm using the term settle because, again, most of the people, you know, that we deal with are fighters. You know, we're going to go to the bitter end. Sometimes that costs, you know, and sometimes you've got to make that business decision, you know, that, hey, it's better for us to settle and move on to something else than it is to fight this fight and end up bankrupt.
Live to fight another day rather than being a martyr for the 2A as a whole.
And it wasn't Remington's decision. Remington didn't make this decision. The insurance company did.
Yeah. Absolutely. And you know, here's the other thing. And Bill, you kind of said this. You know, we get a lot of questions here at FLP regarding, hey, what if someone steals my gun and, you know, they go out and they commit a crime, or, you know, they actually kill somebody, you know, with my gun. I didn't know they had my gun. This kind of is kind of similar to that. You know, under the laws of most states, right? If you don't know something has happened, you know, that someone's taken your firearm, or, you know, that your firearm is missing, how can you be held accountable for it? It's kind of the same thing with your vehicle, right? If your vehicle's gone and some guy runs through a parade and runs over 10 or 12 people, you wake up in the morning, you're like, whoa, that's my car. Where did that come from? That's something completely different than being in a position where, yep, my car was gone or my gun is gone. In this case, I said absolutely nothing. I did absolutely nothing. I want people to really understand this in a more simplistic manner, what Remington did, and how this really a lesson learned per se is basically just making sure that you understand you're responsible for your actions, not the actions of others, much like the settlement here with Remington. Would you somewhat agree with that, Bill?
Yes, but I would like to add that there are places that have laws holding people responsible for the storage of their firearm. If it's not properly stored and it's stolen, there are some laws that say you actually are culpable. So in those places, especially, that is a consideration. Now, if you have done all the right things, you've got your gun stored in a very competent safe or lockbox or something, and that's stolen, in those places, even then you would be absolved because you did everything under your power to take care of that firearm so it wouldn't be stolen. But if you leave it on the dashboard of your car and your car's unlocked with the windows down and someone steals it, there are places that would hold you responsible for that. And there's a lot of people that think that's the right way to handle it. Beyond that argument, which there's pros and cons on both sides, you've got to be careful where you put your gun and how you're going to secure it to make sure that it doesn't fall in the wrong hands. If you've done everything you can and it falls in the wrong hands, that's a different matter altogether.
You know, it's interesting you mentioned that because there's a case here in Michigan that is going on that maybe at some other point we'll have a conversation on. We had the young man that went into Oxford High School and actually killed 6 people. and they are blaming not him. I mean, he's being charged as an adult, but they are charging his parents with involuntary manslaughter, Bill, based upon basically what you just said, that, they didn't have the gun secure. He, the young man, 16, had too much access to the firearm. So, you're right. As long as you do what you're supposed to do legally, it makes life a lot easier for you. So,
and Terry,
interesting.
I was gonna say, just so I understand, that's under Michigan law, not the federal, what is it, Youth Handgun Safety Act, or I forget the exact term, but so they're going after this under Michigan state law.
Well, again, they're going after it under involuntary manslaughter, and I'm not exactly sure how all the pieces connect. And the reason I say that is I think they have a huge legal burden to jump over, not an emotional burden,
right?
A legal burden. So, as Bill mentioned earlier, each state acts differently. So the way you store your gun in, let's say, state of Washington, is probably different than maybe Florida or maybe the state of South Carolina or Michigan. So always know where you are, and those are the rules that apply to you.
Gotcha. And of course, all the responsible gun owners are going to do everything they can to keep that firearm from falling into the wrong hands. But there are some irresponsible people out there that won't act appropriately, and their actions, they need to be held accountable for their actions.
Absolutely.
No one would leave a running chainsaw on a park bench in an area that's full of kids. And they're both tools, the firearm and the chainsaw, and they have to be treated with respect to the damage they can cause outside of the intended use by whomever, either the manufacturer or the owner. And you wouldn't do something irresponsible like that with a chainsaw. You can't act irresponsibly with a firearm under any circumstance.
Yep. And you wouldn't hold Husqvarna or Steel responsible for what that person did.
Right.
Yeah, but we try to do it with a handgun or a Smith & Wesson or Remington or whoever. So,
yeah.
Well, any final words anybody wants to say on this?
I think it's going to be interesting to see how the gun manufacturers adjust, but I really don't believe it's going to harm the industry. I'm incredibly heartbroken for the victims. There's nothing that can be even said that even can get close to a parent like that. But to blame someone who really wasn't at fault is not the American way, but it sure seems to be the way that went.
Yeah. Well, and I just, there's been a lot of confusion on this subject, I think, from people who just look at a headline, don't even read a full news article. So right. I just hope doing this video, sitting down with you two gentlemen and clarifying this kind of stuff, I hope that helped a lot of people. And there's a lot of emotion tied to this subject. There's lives, there's a lot of money. And so I hope this helped in a calm, rational way kind of explain where things are.
Well, and certainly emotion was used to forward the plaintiff's efforts.
Yeah.
Who wouldn't be emotional? Who wouldn't have sympathy for those plaintiffs? So that, I think that was a factor.
Yeah, I think at the end of the day, we, especially as, responsible gun owners, have got to do the right thing with our firearms. It's not only a point of locking it up and knowing who's around it, but making sure that we have firearm education, and just don't make it an object that we tell kids stay away from. We have to educate them. Again, this is just me speaking. I don't speak on behalf of anyone saying this, but want to make sure that we continue to be good responsible firearms owners. And as this moves forward, there are going to be more cases and more things that come out. But remember, this has zero impact on the judicial system. This is just a settlement. Two parties in this case, have agreed. So, and I think we can all agree that we really appreciate all of our members at FLP.
Very much.
And we want you guys to keep coming back for more topics like this. And, plenty. Anything else, Bill?
No, I think we covered it.
You nailed it.
Well, again, we appreciate you folks. And remember, protect yourself. We'll protect you.